Thank you. Chairman, you're live.
All right. It is December the 7th at 1 o'clock, and I would like to welcome everyone to this House Judiciary Committee and Senate Judicial Proceedings Committee joint briefing. It's a virtual committee briefing, so we ask for your patience if we encounter any technological or streaming issues. Before we begin, I remind committee members that this briefing is being streamed on the Maryland General Assembly's YouTube channel. Very happy to have everyone here today. Just a few rules of the road. The committee members will be muted through the briefing. You have a question, type question in the chat box, and we will answer those or call on those people in the order that they're received. We'll be going back and forth between senators and delegates. Today, again, both Judiciary and Judicial Proceedings are going to receive an update from the work group to study child custody proceedings involving child abuse or domestic violence allegations. And we're going to have several people who are going to speak about this issue. The panel includes Secretary of State and the chairman of the work group, Secretary of State Wobensmith. And I apologize if I didn't land that completely correctly. We have a number of other people who are going to be speaking as well, and it helps when my computer works. Ruth Glenn, the president and CEO of the National Coalition Against Domestic Violence. Joyce Lombardi, the director of Government Relations and Legal Services for LifeBridge Health. And Joan Meyer, the professor of clinical law and director of the National Family Violence Law Center at the George Washington University Law School. There are also several guests who can provide information or answer questions during the Q&A portion of the briefing. We do hope to conclude this briefing at 3 o'clock and are very happy that all of you are here today. But before we begin, I'd like to now pass it over to the chair of the Judicial Proceedings Committee, Chairman Smith, to see if he would like to make a couple remarks.
Well, thank you, Mr. Chairman, and I'll be brief. Just want to say thank you to the work group and especially to Secretary Wobensmith. It's a fantastic and very comprehensive report, and I look forward to our discussion today. Also want to thank you, Mr. Chairman, for bringing us together and facilitating this hearing, and Dylan, thank you for all of your work behind the scenes. And then also just for the members of the Judicial Proceedings Committee, thank you for your time and thank you for being here. I know this has been a subject of great interest over the past couple of years, so looking forward to the discussion today. Just one note, many of our Republican caucus members are in another meeting right now with the governor. They will be rolling in once that meeting ends, so you'll see them pop in and out, but that's just where they are right now, so just a little bit of a scheduling conflict there. With that, Mr. Chairman, I'll pass it on back to you and we can get started.
That sounds good. And with that, we're ready for the panel. So Secretary Wobensmith, if you'd like to begin, go right ahead.
Well, thank you very much. Good afternoon, Mr. Chairman, Chairman Clippinger and Vice Chair Atterbury. Thank you so much for organizing this briefing today. We appreciate Chairman Smith and Vice Chair Waltschreiter and all the other legislators present here today as well. And especially thanks to all of you so much for your vote 2 years ago to establish the work group to study child custody court proceedings involving child abuse or domestic violence allegations. I would point out that you have placed Maryland on the forefront of dealing with this issue, which is a horrific problem across our whole nation. Attorneys, advocates, and protective parents across the United States have in fact been following the work group activity and are looking forward to these recommendations and our next steps towards solutions. We recognize and greatly appreciate Senators Lee and Carrozza and Delegates Atterbury and Lewis for their efforts while serving on the work group and in the coming months as they champion potential life-saving legislation based upon the work group's research. We appreciate this opportunity to present briefly the work group's findings and recommendations. And as you know, this work group was established to respond to a devastating problem: the failure of many of our courts to protect our children, And according to the Center for Judicial Excellence, a nonprofit organization that's devoted to family court reform, over 758 children in the United States have been murdered by a parent involved in a family court-related proceeding since 2008. There were 19 such child homicides in Maryland during this period. In our final report, you'll see the report mentions 6, but that's the number of Maryland cases involving clearly reported system failure, where safety concerns were blatantly ignored by the family court. This number has since been updated to 8. And of course, most cases do not end in murder. Instead, innumerable children are sentenced to a lifetime of abuse by the courts allowing access and sometimes awarding sole custody to an abusive parent. Such trauma results in unequivocal long-term mental, physical, and social health effects on these children, as well as the protective parents who also have been denied justice. We had hoped to address these issues alongside the family court and invited the AOC to participate on the work group. And while they did not want to officially sit on the work group, they did attend every meeting, including subcommittee meetings, and answered questions as they were able. And of course, we continue to welcome their input and expertise. Maryland has not re-examined our family court system in over 20 years. We have not implemented new science on trauma or adverse childhood experiences or how domestic violence impacts custody cases. It is known that courts all too often re-victimize our children, yet no changes have been made. In 2013, the Maryland General Assembly established the Commission on Child Custody Decision-Making, and chaired by Judge Cynthia Callahan. Much of their good work and worthy recommendations did not make it into Maryland law, nor have they been implemented by the judiciary. Our work group built upon that work, but focused only on cases involving abuse allegations. The issue is multifaceted. Many factors contribute to abuse, perpetrated unintentionally by the court system. The problems are linked not only to judges, but also ill-equipped best interest attorneys, custody evaluators, and the internal biases and the financial situation of the parties and other factors as well. Our 24 recommendations address many of these issues with an emphasis on the training of judges in order to equip them to recognize the nuances of these cases and mitigate many distinct issues. Our recommendations aim just as much to support our judges as to protect the children. In a few minutes, we'll hear from Joan Mayer, Professor of Clinical Law and Director of the National Family Law Violence Center at George Washington University Law School. She'll provide a brief overview of the presentation she made to our work group, highlighting the great need for movement to ensure justice in custody cases where abuse is alleged. A member of the work group, Joyce Lombardi, Director of Government Relations and Legal Services for the Baltimore Child Abuse Center, will follow to actually outline the work group's recommendations. So we'll begin now with remarks first from Ruth Glenn, President and CEO of the National Coalition Against Domestic Violence. And so over to you, please, Ruth Glenn.
Ruth, you need to, yeah, there you go.
There we go. I didn't know if Dylan was going to do it or not. So first of all, thank you, Chairman Wobenstein, very much for the introduction. And then secondly, I cannot thank Maryland for stepping up and being on the forefront of addressing this issue through this remarkable work group who's really looking at some of the core issues that cause child abuse. The root causes of child abuse, we know from our work, are rooted in domestic violence and other issues. Chairman Smith, Chairman Kleppinger, and then certainly the entire committee, your willingness to hear about this and really take a hard, long look at the issues that cause child harm as it's rooted in domestic violence is really appreciated, and particularly from our perspective. I will give you a little bit of a story. I spent 28 years in state government here in Colorado. And the last 10 years of that, I worked for the domestic violence program within child welfare. And I remember in particular the struggles of supporting and figuring out how to help those that were providing services to children identify the dynamics of domestic violence. I also sat on the child fatality review team. And as those of you that know anything about child fatality and the inordinate amount and the predominance and prevalence of those children that died because there was a domestic violence abuser in the home. Quite frequently, and in fact, I only sat on the committee for a couple of years because it was just too tragic. I personally could not take it. So I understand government and how resources are sometimes limited to help people that are intervening, preventing, and working with those that intervene with child custody matters, whether it's child welfare workers, whether it's advocates on the ground within a government system, or whether it's evaluators, which really do not get the services or the support that they need as well. But in particular, I always found it very interesting for those wonderful judges that are trying to make the right decisions and they don't have the expertise to understand what domestic violence is and how that's impacting when you make decisions about custody. And many a judge felt like they were inadequate, but they also felt like they didn't have the resources to make sure that something happens. So I speak to you with two hats on, one as a former child welfare, domestic violence worker, but also from a national perspective. I'm so pleased that you're going to hear from Jo Meyer. She is just phenomenal in the work that she does. And I can't tell you between her and the work group how much information you'll have to hopefully move forward on some legislative measures that will protect children, and particularly that those numbers that Senator Wobenstein mentioned will be reduced significantly. I firmly believe that training for judges and understanding custody issues as they relate to domestic violence will be life-saving measures for the children of Maryland. I appreciate you all being on the forefront of doing something different and looking at how we can protect lives, and certainly open to any questions that you might have. Thank you so much for inviting me to be a panelist here, and again, appreciate all of your work. Thank you.
Secretary, you're muted. Still muted. You're muted. There you go.
Okay. Thank you very much. And Joan, if you'll continue on, please, that would be great.
I'm happy to. Thank you so much, Secretary Wobensmith, and I echo Ruth's thanks to the chairs of the committees and all the legislators who have taken this step. And I want to underline what the Secretary and Ruth said, which is that the entire nation is watching what Maryland is doing. I have reporters who ask me all the time, is anyone pioneering and anyone ahead on these issues? And I always say Maryland is the only state that's ahead on these issues right now. And we are all very just excited to see the work that has been done and that hopefully will continue to be done here. So I was asked to present some of my data, and this is a very foreshortened kind of highlights of presentation for the sake of time. And we can move on to the next slide, Dylan, thanks. Just very quickly, who am I? Professor at the law school, directing a new center there. I also was the founder and ran the legal work at DV Leap, which did a lot of appellate work. Next slide. That's relevant to why I did this study. Over many years, like 10 or 20 years of doing appellate work and receiving just floods of desperate requests for help and for appeals in cases involving child custody and abuse, I finally decided that, and I had been doing scholarship and trainings and argumentation here and there about the issue of parental alienation, which we found was very often at play in the cases that were going south. And we were finding no shift in the system's response and no shift really in the policy or scholarly arenas either. And it felt like the domestic violence field and the child abuse field were seeing one part of the elephant, and the family court personnel, which includes people who are strong believers in parental alienation, many evaluators, many guardians ad litem or BIAs, and certainly some judges and lawyers, just thought that the abuse field was kind of doing what we do, complaining a lot, and that they didn't need to take it all that seriously necessarily, and there was no data behind it. And I decided we really needed data to portray what is actually going on as an objective matter in the courts. And we were seeing already that child abuse allegations were particularly problematic and were backfiring the worst on mothers who were raising them. And so I decided, instead of kind of complaining and critiquing and all of that, let's just collect some data and see what we can just describe empirically about what's going on. Next slide, Dylan. I applied for a federal grant. It was supposed to be 3 years. It ended up taking 5 years because to our shock, we netted 15,000 cases in our original search and triaged it down to about 4,000. What we did, in order to get a national picture, we focused on electronically published court opinions. So our data set consisted of what judges had written about their decisions. And because they were electronically published, which was the only way to get a national picture, that meant that most of these published opinions were from appeals. But we had several hundred cases in there, like close to 500, I think, cases from a few different states that did not go up to appeal. So I'll come back to that in the end and happy to answer questions about it. But basically, we had thousands of cases over a 10-year period that were described by judges in terms of the judges' decisions that involved alienation and abuse. And we coded many, many things. I'm only going to talk to you about very few of those things that we coded. Next slide, please. Okay, so I'm gonna talk to you today very briefly first about how courts responded to abuse claims empirically. Oh, we lost a number in there, but I know what it is. Dylan, if you can recover those numbers, that would be great. No, I think you skipped a slide. Okay. I'm not sure why that number fell out, but basically, first I'm going to tell you how they responded to mothers' abuse claims. The vast majority of the abuse claims came from mothers. I can talk about the reverse if you want me to later, but for the sake of time, I limited it to the focus on mothers' claims. And what we found overall was that courts credit or believe or validate and accept mothers' reports of fathers' abuse less than half the time. In domestic violence cases, when they're alleging partner abuse, the number that's missing here is 45%. We found 45% of the time only did courts credit allegations of partner violence. And we found that courts credited child physical and child sexual abuse far less. So only 29% of the time did they credit child physical abuse, 15% did they credit child sexual abuse. Now, let me also clarify. We broke down our population so that we could compare what happens when alienation was raised as a cross-claim. So this population where I'm giving you the numbers, 45, 29, 15%, is the cases that did not involve an alienation cross-claim. And next slide will be about, thank you, about, we lost all the numbers in there. Dylan, I'm gonna have to take a second and try to pull up the numbers. I'm not sure why they're missing. Give me 1 second. Okay, so for the alienation, the cases that did have an alienation cross-claim, the way this works, in case you're not familiar, is that if a mother alleges some kind of abuse by a father, very often the father and sometimes the evaluator or the guardian or the judge will bring up the idea that the claim of abuse is not valid. It's really just a way of trying to sever the father from the children's lives or alienate them from each other. And alienation cross-claims that I consider to be essentially a defense to an abuse claim, had a very dramatic effect on the crediting of mother's abuse claims. So whereas originally without alienation claims, courts believed 45% of the domestic violence claims, when you had an alienation cross claim, that fell down to 37%. Whereas originally, without alienation, you had courts believing 29% of child physical abuse. That dropped down to 18% when there's a cross claim of alienation. And most dramatically, when you had child sexual abuse claimed without a cross claim, courts credited a very low amount, 15%, but that dropped down to 2%, virtually zero. It was a single case when a accused abuser responded with alienation claim. Okay, hold on. I'm switching back now to your slides. I'm sorry those numbers fell out. They're in the original PowerPoint. Hopefully you have them in what was sent to you. So if we can go to the next slide, this synthesizes all of those numbers. What it shows is that when alienation is cross-claimed, it reduces the likelihood of any abuse being believed by a factor of 2, and it reduces the likelihood of child abuse being believed by a factor of almost 4, which is, if you want to discuss or know more, not surprising, because alienation was originally invented as a way of defeating child sexual abuse allegations. And sure enough, empirically, this finding is driven primarily by the child sexual abuse cases. Let me just remind you, though, that even without the alienation cross claims, the rate of crediting of mother's abuse claims is shockingly low. There is really no basis, there is no support empirically for the idea that women are lying or wrong about partner violence or child abuse to the extent that courts are saying they are. Okay, next slide. And I just want to put a point on the sexual abuse. And again, we seem to be missing a line. Do you want to try clicking that? There we go. Okay. So as I said, in the study, we had 51 cases where the mother alleged child sexual abuse and the father responded with alienation. Only one of those cases did a court believe. And just to give that context, there have been quite a few, or at least a significant small number of studies, large studies, that have found that 50 to 73% of child sexual allegations in custody litigation were likely valid. So there's absolutely no empirical support for the idea that 50 out of 51 mothers was lying or crazy in these cases. And what that means is that these children were not protected. Next slide. Which brings me to the other thing that we have analyzed so far. There's many more things that our data show. For instance, the issue of visitation, which I know is a big issue in the cases in Maryland. I haven't done that analysis yet. What we've started with is just looking at custody switches, by which we define them in terms of who starts with primary care, physical care of the children, and who ends up with legally awarded primary care. So it's a narrow definition, and we narrowed our scope to look at those cases where that's switched. And when we looked at that, cases where we could measure who started and who ended with custody, what we found was that when there's no alienation claim, mothers are losing custody about a quarter of the time. In DV, where they allege DV, they're losing it a little more when they allege child physical, and about the same when they allege child sexual. But when there's a cross claim of alienation, consistent with what I just said about courts' reactions to the credibility, what you see is that custody losses also shoot up from 23 to 35, from 29 to 59. That's doubling the rate at which mothers lost custody when they allege child physical, and from 28 to 56, again doubling the rate at which mothers are losing custody when they allege child sexual abuse if alienation is cross-claimed. Neither one of these is great. Given what we think we know, it is unlikely that all of these mothers should lose custody and that all of these children are safe, even when you're talking about a quarter of the cases. But here you're talking about a third to over a half when it comes to alienation cases. So overall, this averages out to the finding that cross claims of alienation increased mothers' custody losses from an average of 26% to an average of 44%. Next slide, please. One last point here, which is a little shocking, that even when courts said they believed an abuse claim, in 62 cases of domestic violence or child physical, where they said, yeah, we think he did that, they still took custody from the mother and gave it to the abuser. What's striking comparison here is that that didn't happen when they believed child sexual abuse, which is great news. They didn't give custody to child sexual abusers, but they did give it to batterers and to people who had been found to have committed some kind of child physical abuse. Okay, next slide. I was asked to say a little bit about what I called guardians ad litem, and I think Marilyn calls best interest attorneys and evaluators. So next slide. Yeah, sorry, these were kind of animated. I forgot to take all those out. Dylan, maybe put the next one. Okay. So what we found with regard to attorneys for children or for children's best interests was that sadly and counterintuitively, they do not help mothers and they do not help children who are alleged to be abused. In fact, mothers are 3 to 5 times more likely to lose custody when there is such a professional in the case, and particularly when the mother is alleging either physical child abuse or a mixture of physical and sexual child abuse. So again, what you're seeing is these lawyers for children are reacting very negatively to allegations of any kind of child abuse, basically. Less of an impact, no statistical significance in the DB cases we found. But for comparison purposes, we were able to look at cases where fathers alleged mothers were abusive, where there were appointed lawyers, GALs or BIAs, and there was no statistically significant impact on protective fathers' likelihood of losing custody. So here we're seeing clear gender bias, and there's more to be said about gender bias, but this is a larger population of cases than the one where I'm comparing alienation to non-alienation. This mixes them all together, it gives us more data, and we're able to say more about gender comparisons in this population. So you see that with the BIAs. Next slide, please. And unfortunately, you see the same thing with evaluators. What we found was that when an evaluator was present, mothers were 2.5 to 6.5 times more likely to lose custody. And the peak was when they were alleging, again, this mixture of child physical and sexual. It seems like when you allege both kinds of abuse, it somehow seems to backfire more strongly on mothers even than alleging one kind. And this, again, we found that there was no statistically significant impact of the presence of an evaluator on protective fathers losing custody. Next slide. So that's sort of all I wanted to give you in the way of highlights, but I want to also touch on the limitations of the study, some of the things that I think are legitimate questions that can be raised. This study does not second guess the fact finding. It does not go in and conclude that the mothers were telling the truth or were not telling the truth. So one can say the courts are fine if one agrees that it is likely that that many women are not telling the truth. And that's not something the study could answer. The other significant thing is that, as I said earlier, because we had to use electronically published opinions, or frankly, published opinions, and primarily only appeals are published opinions. Usually trial courts don't publish, although we found 400 or so case courts that did publish their opinions. While we analyzed, even when we had appellate opinions, we were analyzing the trial court's actions, and all of this data is talking about trial court actions, not appeal courts. But because we had so many appeal cases in the data set, that could tilt the numbers we found. And so we looked, if you look at the asterisk, we did do a comparison between the opinions that were from trial courts and the opinions that came from appellate courts, where we also analyzed trial court, to see if that was a different population, the appellate population. And we did find a higher rate of custody losses in the appellate population, which is not surprising because you would expect more appeals when mothers are losing custody than when they're not. And so it is likely that our custody loss data is a little tilted higher because of the high proportion of appellate decisions in our data set. But generally, the validation or crediting numbers, the gender bias numbers, the role of GALs, et cetera, we did not find a difference between the trial court opinions and the trial court decisions that went up on appeal. Oh, and lastly, again, because we had to use published opinions from judges and we couldn't go behind them to look at the record or look at the facts, we're dealing with thousands of cases all over the country, we had to rely on what the judge did or did not say in the opinion. And we categorized them as abuse or non-abuse or alienation or non-alienation cases based on what was in the opinion. We do suspect that some judges and some opinions don't mention allegations of abuse or alienation if they fell out along the way and the judge decided they weren't significant, and in the end, when they wrote their decision, they don't talk about them. So in that sense, our comparison between abuse and non-alienation and alienation cases may not be precise, but we think it's still a very powerful comparison. And if anything, if we were able to get the accurate answer on these cases and whether they had alienation claims in them or not, we think the data would be even stronger, because the cases that we don't put in the alienation category that are in the non-alienation category would actually strengthen the alienation category if we knew they were alienation cases. Anyway, that's a little complicated, but bottom line is we don't think this really affects, although this is an area of potential slippage and argumentation, we don't think it really affects the overall findings and conclusions of the study. Next slide. And so finally, I'm sorry that came out purple. I fixed that before I sent it to Dylan, but again, hopefully you can see it in the ones that were sent to you. But the published study is available. There's one in a journal article, and there's one that was the NIJ report that was submitted that's online. And I'd be happy to be contacted with further questions, or if anyone would like to see the study or the report. And I would love to have you join my new center's electronic e-list. We don't write more than once a month. It's going to probably be less than once a month. And if you'd like to join, just send me an email.
Joan, thank you very much for that. And we'll have a chance again for additional questions later on. What we'd like to do now is have Joyce Lombardi go over the various recommendations. So Joyce, over to you.
Great, thank you. Good afternoon, and thank you, Secretary Wobensmith, Chairman Smith, Chairman Klippinger, and all the members that are here today. It is so nice to see many of you. So I am Joyce Lombardi. I'm Director of Legal Service and Government Relations at Center for Hope, which was Baltimore Child Abuse Center, which is a child advocacy center. I am a member of this work group. The people who are also here, who are also members of the work group, any of them could also be presenting the findings today. I got the short straw or the long straw, as you want to see it. So I'm going to be presenting them. And I do want to say, because I am a lawyer, what I'm presenting is the recommendations from a group. We worked in subcommittees, and so this is a group process. This is not necessarily LifeBridge Health, Center for Hope, but this presentation that I'm making is on behalf of the group. And so before I go into those, I will just say the reason that I'm even on this is because I run a legal service program at a child advocacy center. Many of you know, because you passed our child advocacy bill, thank you, that the Child Advocacy Center, we are the place when there's an allegation of sexual abuse, physical abuse, witness to violence, human trafficking, law enforcement, CPS, they bring the child to a child advocacy center in all of the counties in Maryland, across the country, and we do the forensic interview. We have mental health, we have medical, and so we listen to what children are saying. And I'm just going to say this too. I think Professor Meyer alluded to about a deluge when she started looking into this. I thought legal services was going to be helping kids and families navigate the criminal justice system. It is not. My work primarily and especially during COVID, I have my number one call that I get as I'm sitting here. I just got another client that texted me. Number one call that I get is parents who there have been allegations of abuse in their family, and the protective parent is home, and there is a modification of custody, there is a court proceeding, and she or he, there can be men, I just want to say that too, is the protective parent, more often than not women, can be men, are having to go pro se into these proceedings. They don't have a lawyer, they don't understand, and unfortunately, what you find is that the judges and the court personnel don't understand enough. We do a lot of training with court personnel, lawyers involved in these cases. The demand is huge. So I just want to say that. And also this work group builds on the work from Delegate Dumais, from Barbara Babb. We stand on the shoulders of people who have really been looking into this in Maryland. And so Maryland really is a leader. Let's go. And also the very first thing I want to say too is that the recommendations that I'll be reading, there's 22 slides. I'll try to go quickly, but the Maryland Department of Legislative Services did a phenomenal job. You guys have the link to the full report. And so a lot of the really details of these recommendations and so forth are in there. So with that, we can go to the next slide. And there it is. There's the link to the final work group report. It's 124 pages, but very, very, very comprehensive. Kind of gives you the why and the background and some of the history and some of the other people, some of the great work that Professor Meyer did and some of the others who came and spoke to us. So the recommendations that you'll see on the slide, next slide, please, Dylan. We kind of summarized them. Please, oh please, just the lawyer in me is going to say, go back to the report for what the actual recommendations are. And these are recommendations. This is not a hearing. This is not legislation. This is just saying, hey, we've looked at the universe and here is what we think. Let's start with the first one. Best interest factors. This one's kind of straightforward. And actually it builds on work that was done in 2014. Exactly this. And it just said, hey, in Maryland law, we have our best interest factors and best interests of the child, right? In a custody proceeding, family law, what are the best interests of the child? That is a standard. In many states, those are codified into the statute. In Maryland, they are not. They are common law. And so this recommendation number one simply says, please codify the best interest factors that we use anyway into the statute. Why? For the reasons we always do. It helps pro se litigants. It helps everyone, judges and courts. We all understand the factors. It also, one of the other recommendations also says there are extra considerations for joint custody. And we ask that it's not necessarily presuming that joint custody is always in the best interest of the child. Go through the factors, listen to what the litigants are saying. So that's number one. Next slide, please. Number two, this really kind of strengthens family law statute, family law 9-101, and it simply asks the judge to articulate their specified findings on the record so it's clear which best interest of the child factors they weighed in their determination. So the purpose of this is to clarify why the finding was made and assure that the judge kind of followed the best interest child standards that are in common law. Of course, the judge has discretion. This doesn't take that away. It just simply says, please articulate on the record why you made the findings. And this is specifically going after family law 9-101, which says if a court has reasonable grounds to believe that a child has been abused or neglected, the court must determine if an abuse or neglect is likely to occur. So that's what the law says. And this says if the judge is going to make findings that abuse or neglect is likely to occur or not likely to occur, please tell us how you reached that decision. So that is what this does. Also in recommendation 2, for any of you who read it, it also asks for clearer guidance on supervised visitation, on how that process works, similar to a law, Senate Bill 594 from 2020 from Senator Susan Lee. During COVID, we didn't have time to get to that. Next slide, please. Number 3. Definitions for child abuse and neglect, pretty straightforward. So far in the family law statute that governs the custody proceedings, which is family law chapter 9, there are no definitions for abuse. And so often family courts will use the family law SINA cases or the DSS family law definitions as opposed to these custody cases, or they'll use the criminal law ones. The standards are a little bit different, and so please provide specific definitions for abuse. The family law ones are, usually are triggering event if a child or if the state is going to intervene to lose custody. Child abuse and neglect, private family, different standards, slightly different. So we just ask that we just codify very specific definitions there so judges don't have to go and look and try to cobble things together. Next slide, please. Number 4, child custody proceedings involving domestic violence, same thing. We'd like to amend statutory law regarding acts of domestic violence in the context of child custody cases. You heard about this earlier. And just slow down for a second, to establish a rebuttable presumption that custody, physical or legal, to a perpetrator of domestic violence is not in the best interest of the child. 21 other states do this. District of Columbia does this, as it says in the final report. It asks that the judges articulate the standard, how that presumption can be overcome, establish the determination and actions that are required when domestic violence has been committed by both parties. That's something that people have seen in court, and specify examples of permissible custody or visitation arrangements to protect victims of domestic violence. As you'll see in the final report, Wisconsin does this, so that's where this comes from. So the intersection, of course, child custody and domestic violence, something that the group considered. Next slide, please. Number 5, again, definition for domestic violence. Again, in Family Law 9-101, the definition is drawn from Family Law 4-501, which is the eligibility for a protective order. And this is the same thing. The work group just asked for a definition of domestic violence that reflects the full spectrum of abusive behavior, family situations, non-physical acts. And the example given in the final report is, you'll see, for example, coercive control, psychological aggression, some things like that. They're not exactly the same as in SINA and criminal applications. Next slide, please. Anyone thumbs up or thumbs down? Too slow, slow down? Anybody? Put it in the chat, but I'll keep going at this pace unless someone tells me not to. All right. Number 6. This one, specify in the statute that the provisions of 9-101 and 9-101.1, those are the factors. Those are the factors for awarding custody and abuse situations, do not apply to SINA cases. And so what this is really doing is, you'll see on the bottom, it's just a clarification of existing interpretations to minimize confusion. What you're seeing is that when sometimes the 9-101 custody factors are being used in SINA cases, and so this is just kind of making it clear to the courts, like, we have custody cases, we have SINA cases, not exactly the same thing, and it just clarifies that. The standards should be different, said the work group, because they're different animals within state intervention. Next slide, please. Recommendation 7, the friendly parent provision. This one that says, alter the current friendly parent statute so that reports of child abuse or domestic violence cannot be considered unfavorably against the reporting parent. Again, as you'll see in the final recommendation, in the narrative, it's currently the friendly parent is the one who supposedly promotes a good relationship with the other parent. In Maryland law, we do it a little bit different right now. In Chapter 9, it says if the court finds a parent has unjustly denied visitation, the court can take action. And so that's a little bit different. And this just says, hey, courts, if you're going to do that, don't say that you're unjustly denying visitation because you're alleging abuse or domestic violence. So don't necessarily use that against us. That's recommendation 7. Recommendation 8, judicial training. So currently, judges are trained, they get about 12 hours annually. Might get that wrong, just the final report lays it out. They have a family law university of about 20 hours, if I'm not mistaken. And so recommendation 8 says, listen, not all members of the judiciary, but for those judges who do family law cases, who do this presiding over child custody cases that include disclosure, discovery, child abuse, for certain judges that do this kind of work, in consultation with appropriate domestic violence and child abuse advocacy organizations, please develop an ongoing training program that gets a little bit more into depth of the abuses, of child abuse, dynamics of sexual abuse, adverse childhood experiences, the things that would be very helpful in a court proceeding. Exhibit 5 lists out what all of those are. And then the recommendation is also judges presiding over these cases must have at least 60 hours of initial training of these topics. Those topics, again, what is Child Advocacy Center, some impact of domestic violence. There's a longer list, but it's a little more in depth of what judges do get now. Texas, Minnesota, California, there's some other states that are very specific about what they require. Final of this recommendation, I'm sorry, there was one more on that slide. It's really quick just to say 60 hours initial training, at least 10 hours of ongoing training every 2 years. That's the last bullet point. So 60 hours, 10 hours every 2 years. Okay, next slide. Thanks, Dylan. Number 9, specialized judges. And this will say, to the extent practicable, only assign custody cases with disclosures and discoveries of child abuse or domestic violence to judges who have been specifically trained. Courts should implement procedures, including appropriate uniform screening of initial pleadings that flag child abuse and domestic violence. Please only give those to specially trained judges who have gone through this 60 hours plus 10. And also those specialized judges would be familiar with the protocols for the safety of the adults and the children. They would understand safety plans, DSS. They would understand that a little bit better. This is a specialty field for anyone who's in it. And so this recommendation summarizes that finding from the work group. Number 10, please. This recommendation asks that the judicial nominating commissions include an individual who has expertise in child abuse or domestic violence, or otherwise receive input from such an individual regarding those nominees. Again, same thing, developing a deep bench. Next slide, please. Number 11, training requirements for child's counsel. Catch-all, please alter the existing training standards for Maryland's best interest attorneys, child advocate attorneys, and child privilege attorneys. Those of you who work in this field in Maryland know that there's 3 kinds of attorneys who are often appointed in court cases, and so that's why it's broadly written, so that these attorneys must complete at least 60 hours of initial training and, like the judges, 10 hours of ongoing training every 2 years, so the same amount. The Maryland rule currently on this, or the law on this, 92051, current training requirements are a suggested, not mandatory, 6 hours for best interest attorneys. For some child's counsel, only 6 hours on a variety of family law topics, not just child abuse and domestic violence or abuse, but all kinds of family law. And I think maybe 3 years of experience. So this, from a suggested 6 hours to a mandatory 60, is this recommendation. Next slide, please. Be happy to know it's 2 for 1, 12 and 13. Now this is getting into custody evaluators. These are for those of you that don't know, in the family law proceeding, custody evaluators are the ones who are appointed by the court, who actually have a special role to come in, look over the evidence, and then give a recommendation on custody. And what the work group asked that custody evaluators have a master's degree, that the existing training requirements be also 60 hours of initial training, and also the 10 years every 2 years. Under the current Maryland law, there are the current training requirements can be waived if there's a certain amount of experience. I think it's 5 years. And so this one just says, hey, let's make this like the judges and the others. There was, and just so you know, there's been a lot of talk in other states about abolishing custody evaluators altogether. That's background. And so what the Maryland work group came with and said, well, let's just up the training. I see a question. Is that we're going to handle questions at the end?
We're going to handle questions at the end.
That's fine.
Just yet, yeah.
Keep going.
Yep, please.
Here we go. Next slide, please. 14, 15, and 16. Again, a 3-for-1. Again, on custody evaluators, additional qualifications. And you can read these. Please have, if the custody evaluators, this is not all of them, but those who are doing an evaluation that includes disclosure or discovery of child abuse or domestic violence, please have experience under clinical supervision or knowledge of these particular areas. It's its own, it is its own discipline. Please, let's create a standardized credentialing certification across mental and behavioral health disciplines. Courts must ensure that an individual has the requisite credential or certificate before appointing an individual as a child custody evaluator. And it also recommends penalties against any custody evaluator who provides legal advice. Again, as you'll see, these 3 recommendations are linked, and they come from some past experiences in Maryland and otherwise. Next slide, please. 17 and 18, notice and disclosure. Again, this is a custody evaluator one. So in any action in which there's child support, custody, or visitation is at issue, please, the court, we're asking that they provide information to the parties regarding the role, availability, and cost of a custody evaluator in the jurisdiction, and then require custody evaluators to disclose policies, procedures, and fees prior to an engagement in a written document that's signed by both parties. This one's pretty straightforward, similar to Senate Bill 665, also introduced in 2020. Next slide, please, Dylan. Fee structure. Mandate the implementation of an income-based fee structure that includes a cap on fees for custody evaluators. As you'll see in the final report, custody evaluators, custody evaluators charge between $100 and $300 an hour. We have people who gave testimony to the work group of fees going into the tens of thousands of dollars. And so this one is just says, hey, please be transparent. Number 20, kind of roll through these next ones really quickly. Depositions. Custody evaluators under Maryland law can only be deposed for 2 hours. This just says, hey, please up it to 6 hours, because lawyers need to ask a lot of questions. Number 21, next slide, please. Uniform requirements all over Maryland. We heard from different jurisdiction, all over the place, subjective and consistent. And so we would like to simply to say uniform requirements for what custody evaluators are required to do, what's in their report, what they're supposed to look at. There's Maryland, the statute 9205.3 lists out some things, and it just makes it more uniform. Number 22, next slide, okay. Additional considerations. And this one just says, requires the court to consider whether the best interest of the child mandates that a temporary order be issued to limit or suspend or deny visitation. I can tell you this one is really important. All these things are going on. There's allegations. It's moving target. You know, like, do I let the child go over to his mom's house with the boyfriend there and the abuse, or do I not? Like it's like that's a really important, like the temporary visitation. Please, oh please, improve that process for our kids. Huge need. And I think that is, okay, 2 more. Next slide. Record keeping, straightforward, make it uniform. Number 24, next one. Access to relevant resources. And this just says, please make all of these resources available, accessible to parents without causing financial hardship. A lot of in the family court proceeding, custody, a lot of the specialized custody evaluators or others, it's become almost a cottage industry. It can get very expensive. Pro se litigants, this is an access to justice issue, and so that is what 24 says. Final one, last slide, recommendation 25. Oh, that's it. It's not a recommendation, it's actually our last slide. And it just says there, you can read all of that for yourself in its final form. And thank you.
Joyce, thank you very much for taking a heavy load on that. We appreciate it a lot. I want to point out that we have a whole group of folks. We have 6 additional people that are here to respond on the questions, and we're the key people that actually deal every day with victims, and either in court or in therapy or in involving with all of those. If I know we have a little bit of time, I think, so if we could just take a couple minutes, and I'd like the 6 to just quickly go through, identify themselves, and a little bit about anything that they'd like to add on the specific recommendations that we just went through. So if we could start with Camille Cooper, that would be great.
Good afternoon, Chairman, Secretary Wobensmith. My name is Camille Cooper. I am Vice President of Public Policy for RAIN. RAIN created and operates the National Sexual Assault Hotline, as well as the DoD Safe Helpline. We serve about 35,000 people a month at our organization, and we have served well over 3 million people in the last 25 years. One thing I want to point out is that starting in March, the first 3 weeks of March during COVID, we crossed over on our online hotline. 50% of our users became minors. Of those minors that were coming to our hotline to seek support for sexual abuse, 67 identified their perpetrator as a family member. 79% said they were living with that perpetrator. In 1 in 5 of those calls, our hotline staff had to do crisis intervention, and we connected those minors directly to 911 and stayed on the line with them until police arrived at the home. I can't stress to you enough how dire the situation is with regards to child sexual abuse, and in particularly intrafamilial and parent perpetrated sexual abuse. I think it's much worse than any of us even know. Just the number of substantiated reports by social services in 2018 was 47,000 children across the US. That number is very low considering only 50% of Child Protective Services sexual abuse investigations involve a concurrent law enforcement criminal investigation with social services. We have a very dysfunctional Child Protective Service law enforcement collaboration model. It's not working. What we're seeing as a result are the cases that you see in Joan Meyer's study. And I want to stress that Joan Meyer's study is the tip of the iceberg. The majority of those people were on appeal, which means they had resources to go to appeal. Going to appeal is a very expensive endeavor for people. So that means there are a lot more cases that we can't see because they never came up through that appeal pipeline. With regards to the recommendations, I want to stress that I think top down is incredibly important. If we only focused on custody evaluators or guardian ad litems, the judges would still be making horrendously dangerous rulings in these cases. So as an order of priority, I would stress to the committee that the issue with judges not getting these cases right, really getting them dangerously wrong, even in cases sometimes resulting in a child fatality, that we have to get that judicial piece right. So I would ask that the committees going into the next session, please focus on that piece. I'm gonna depart from my colleagues on the task force on just one piece. It gives me a little heartburn on the custody evaluator piece. I don't believe that custody evaluations are appropriate in cases where there are allegations of abuse or neglect. I think it's a little bit of putting the cart before the horse, and the issue of abuse has to be resolved. It has to be resolved well. The children's safety has to be a priority. And I think that inserting a custody evaluation when the issue of abuse hasn't been resolved exacerbates the parental alienation conflict that we see in Professor Meyer's research. So that's what I wanted to say today. And I want to thank Secretary Woban-Smith. This is incredibly important work. And these types of cases are going on in every state across the US. So I thank you for your leadership.
Thank you, Camille. How about Paul Griffin next?
Yes, my name is Paul Griffin. I'm the legal director of Child Justice Incorporated. We're an organization here in Maryland that litigates these cases. We do custody cases on behalf of the protective parent in cases involving domestic violence and child abuse. I'm a member of this work group, and I can tell you my experience, of course, by definition, are anecdotal. It's what I observe, but it was very, in a way, heartening, but also disheartening to have the scientific evidence put in front of us that reinforced what we've been seeing. We brought in experts from various parts of the country. They all weren't just local, who came and testified and provided great testimony, science to back it. We had another national examination that was done for the Department of Justice with a lengthy report by Dr. Dan Saunders, who came and testified that reinforced a lot of what we were seeing and from which we drew for our report. I hope that that the members of both these committees will read the report itself, and as legislation is arising this session and in future sessions, that you will hopefully take very seriously what we're offering. We recognize that there is going to be some issues out there, some opposition to it from various organizations and folks. We hope that you'll give great weight, though, to what the science is showing, and not to perhaps alarmist declarations about this is going to bring the whole thing down or what have you. I also want to thank Secretary Woban-Smith and Senator Lee for their leadership on this. This was a great group they brought together. We really appreciate all their efforts, all their work, and we look forward to working with the Senate and House committees going forward.
Thank you, Paul. Ann Hoyer?
So good afternoon. I'm Ann Hoyer, the director of the Safe at Home Address Confidentiality Program that's administered out of the Secretary of State's office. And with this office it'll be 7 years in March. And prior to that, I'm actually also a protective parent. I actually walked through the court system back in 2005. There were allegations of abuse. And fortunately, I was one of the lucky parents who was able to protect my child, not because they deemed that anything happened, but just the overall, my ex didn't do what he was supposed to do. So I became that 1% lucky parent that was able to protect my child. Happy to say she's 18 and she's doing great. So that was my first experience with this. So this has really chosen me. Nobody wants to get into this line of work. That's why I'm so passionate about it, because I understand it. I get the dynamics of it. So I wear a couple different hats. So right after that experience, I started to work. The therapist and people were reaching out to me to talk with other parents who were going through the same system. I found myself walking protective parents through a very broken system. And it was disturbing on all levels, between CPS, therapist, and the whole 9 yards. So I was very excited to have the opportunity to work for the Secretary of State's office and help others. We provide an alternative address for people who are in abusive situations. And most of these people, I believe we have about 1,300 participants, and most of them are moms with children. So you can imagine 95% of them are caught up in the court system. So I'm hearing the same dialogue over and over and over. It is the same dialogue and different names. So it became extremely frustrating to me. So knowing that this happens, and it happens so often, and people don't understand this, I'm so grateful that the General Assembly, all of you, passed this work group, because we've done some excellent work and investigative work. So I'm just thrilled to be where I am today. I've mentioned this to the Secretary Wovensmith, that this is surreal to me, that this is brought to the table, and we're shining some light on this. I get many calls, emails from advocates, from professionals, from legislators throughout the entire country, calling and going, how did you guys in Maryland get this work group established with the frontliners? And that's really what it's about. It's about the frontliners. You know, as much as we want to protect the judges, I think that's incredibly important. I've spoken to judges who were on the bench, who made rulings that ultimately ended the life of a child. And one in particular said to me, Anne, had this work group been established and had legislation been in place where he had the tools in the toolbox, that little boy probably would have been alive today. So this is, I just want to really stress how important this is to me and to everyone else, and to all these women and some men that I speak to weekly and my staff deals with. It's just, it's got to stop, and it has to be now. It has to be now. We can't wait on this. So thank you so much for having me here. I appreciate everybody being together.
Thank you, Ann. Claudia Remington.
Good afternoon, chairs, Clippinger and Smith, and all the delegates and senators here today. My name is Claudia Remington. I'm the Executive Director of the Maryland State Council on Child Abuse and Neglect. We're required by Child Abuse Prevention and Treatment Act, as well as Maryland legislation, to make recommendations annually to the governor and the General Assembly here in Maryland about child abuse and neglect. And it's been an honor to be a part of this work group, doing really significant work around child abuse and neglect and domestic violence. I am also, the council has been leading an initiative in the state called Maryland Essentials for Childhood. It's partners across the state that are interested in the science of the neurobiology of child development, adverse childhood experiences study, epigenetics, and how trauma is impacted intergenerationally, as well as how to build resilient communities. And so that work really connects to this. As many of you know, adverse childhood experiences impact 3 of the issues that we're talking about here: domestic violence, child abuse, and all forms of child abuse, and also divorce and separation. The decisions that courts have to make in these cases are based on the best interest of the child. They are among the most difficult and complex decisions that courts have to make throughout the country. And in Maryland, we have not looked at the standards that we use for best interest. Judges, people seem to think this is intuitive. And what we know from the science is that since 1996, when the Adverse Childhood Experiences Study just first came out, to all the explosion of neurobiological science that shows the impact on children, we have not looked at the standards that judges use to determine the best interest of the child. Both our common law and the common law was set in 1977 in the Saunders case. Taylor expanded on that in 1986, but there has not been legislation to really look and put these into proper order for judges to really put front and center the safety of children. And it's not just the physical safety of children. I think a lot of times when people hear safety, they think the most important thing is physical safety, but emotional safety is really significant for kids, and even more so in a lot of cases. And when kids' bodies are in constant contact with these kind of traumatic experiences, their bodies respond with flooding them with chemicals and hormonal changes and changes in the brain. We know all this now, and we know better, and we know the science now, and we should make sure that our law is really supporting that science. So I think the taking a look at in the first recommendation, the focus on child safety first as best interest is really critical. And then also in the recommendation around the training that judges and all the attorneys and the custody evaluators get in these cases is really, really significant. Thank you.
Thank you, Claudia. Lori Ruth?
Good afternoon. Thank you for having me. It's an honor and a privilege. It was a very interesting process to be involved in this work group that worked really, really hard. And I think there was a tremendous learning curve for a lot of people who are not, they understand the social science issues and the research and whatnot, but they don't necessarily understand legal processes. And so it was important for people on the committee to learn, things like judges have to abide by the rules of evidence. So it's been really educational for all of us. I absolutely echo what Claudia just said, that I think that it is incumbent upon us to urge the judiciary to update their training to incorporate new science that has been learned. And I think that's a very important piece of this, whether that can be done statutorily or by working with the judiciary, which is, I like to remind people, an independent branch of government. I also found that the Women's Law, I'm the legal director at the Women's Law Center in Maryland. We work mostly with intimate partner violence or domestic violence, less so with child abuse and child sex abuse. There is an overlap, but I found on this committee that it's not as broad of an overlap as you might think when you're trying to drill down into the analysis of this. So I learned a lot from people who, like the psychologists and whatnot, who really know child psychology and brain development. It was very, very educational. But sometimes it was not a perfect match on this committee between these different topics. So I appreciate that. Now I'm going to diverge a little bit from this recommendation to tell you what I think is the most important thing coming down the pike for our legislators. And while I get to have you all here, I'm going to say it. And that is VOCA funding. The legal services in Maryland are facing a tremendous problem with federal desires to cut VOCA funding by millions and millions and millions and millions of dollars. This money comes through to GOCAP, which is the Government Office of Crime Control and Prevention. It has a new acronym that I can never remember, but you know what I'm talking about. And I think almost everybody who does legal services for victims of domestic violence, child abuse, child sex abuse are going to be facing staff layoffs and cutting of services if something does not happen to protect this VOCA money on the federal level, and then have GOCAP be transparent and forthcoming about who they're giving that money to and for what kind of services. So that wasn't the focus of this work group, but I'm urging you senators and delegates on this call to please, please, please pay attention to this. Second to that is the funding for the Maryland Legal Services Corporation. As you all may know, they have 2 months ago, a $9 million deficit. We need money to be able to serve the people that this work group has been trying to give a voice to. It is vitally, vitally important. Thank you very much. I won't take any more time.
Thank you very much, Lori. And finally, Dr. Jennifer Shaw.
Yes, hi, thank you. Thank you, Secretary Rubin-Smith. This has been an honor, and Anne, I want to thank you for spearheading this with your passion and your full heart. Pleasure to work with all of you. I could talk a long time about the impact of child abuse because I am a provider I work with children as young as 2, and then I work with adult survivors. I am a founding partner at the Gill Institute for Trauma Recovery and Education. We're a group practice, and we see children as young as 2, and we provide play therapy, art therapy, and family support services. They're not all sexual abuse, but that is a subspecialty for most of the therapists that practice at Gill Institute. So my, staying in my lane as a provider, I tried to offer this work group all the anecdotes that me and a lot of providers share. And that includes when cases are court involved. And I would say for me and on behalf of, I'll say I was a grown-up voice for the kids that have shared and showed things in my office, really trying to get to a place where all systems of care have the same set of facts about child abuse, about the impact of trauma, about the impact of not treating trauma and not protecting children. And that we have the body of science, neuroscience, child development, child psychology, developmental psychology. We have that set of facts. And that's not always given in a courtroom where there's life-altering decisions being made. After a trauma has happened, while that can be devastating and it can derail development, we find the most important thing, we being providers, to be what happens next to that child. What happens next in their life? That's called a protective factor. So if abuse is disclosed or discovered, and using discovered just to mean young children may not disclose verbally, they disclose in all sorts of ways, whether that's art or play or a rapid change in behavior with no other reason for that change. But we don't look at any of those in isolation, but when it, what's presented is a manifestation of traumatic stress, we do try to then take steps to protect the child during an assessment process. So what can happen, though, is if there's active court involvement, a child can go back and forth between a safe home and an unsafe home. And children cannot recover in that circumstance, because essentially toxic stress remains in their brain, even if in their safe home 50% of the time. So they can't be treated. So my point is, for me, what felt most important is to really speak to, it's really what the system does to protect children that determines their recovery. The ACE study, of course, is informative about what happens to a child, but it's really up to the adult world to say, I believe you, we're gonna protect you until we find out what's going on. And if it's discovered, we're gonna see if it's where will this child most likely recover, which parent can facilitate recovery, and that being the guiding decision. I did want to speak just for a second on what Professor Meyer spoke to with alienation. In our field, it's kind of common when there's a court-involved case, an allegation of abuse, that we hear the word alienation. And I'll be honest with you, if a protective parent shows up in my office for an intake and she doesn't have much money and she's in a traumatized state, so she's anxious and she's flooded, and she's got one hearing after another to protect her child, unfortunately, we feel like she has an uphill battle because she will present as traumatized, which means disorganized. She won't have the resources, and she'll have to prove that she's not alienating, that she's protecting. And that is a common experience of providers sitting with protective parents, that the moment a child discloses to them, and I will add, the reason children disclose to a protective parent is because they feel safe, not because they're being coached the vast majority of the time, but because they feel safe. So of course they disclose to the protective parent. So the evidence would include the protective parent's report because they're with the child much of the time and have a safe relationship. So that's what I would say is, I'm thrilled to have been able to give kind of my anecdotal experience, but this is an incredibly important effort. And just to underscore, these are life-altering decisions. If it's a physical injury, if a child has a broken leg, we would want that child to be in a home where there can be full rehabilitation, there can be assessment of the progress, we can make sure the body can heal. And in this case, it's a developing brain, and it has really far-reaching implications if we don't pause before making a decision about where that child can best heal and ensure it's not further damaged. Thanks again, everybody.
Thank you very much, Jennifer. And ladies and gentlemen, as you can see, we've got some of the best and brightest people in this particular area, and we've been blessed to have them all. I appreciate all the work that every one of them has done. So at this point, I think we can take some questions.
I believe I'm first.
All right, let me just to put it on the record. Delegate Davis is going to be first, then Senator Hellman. Delegates Erican, Cardin, Cox, and Williams. Thank you very much. Sorry, Delegate Davis, go right ahead.
That's fine. I'm Delegate Deborah Davis. I'd like to first thank the committee and all those who worked on this very important issue on protecting our kids. I am a person who always looks at potential legislation regarding through a racial equity lens and a social economic equity lens, especially when we talk about dealing with families, because culture and economic status, all that stuff affects different people differently. So it's really important that we look at, that we evaluate potential legislation under those lenses. So to that end, my first question is, what has the committee done to incorporate that analysis? And I want to add that I know personally that the Center for Urban Families in Baltimore City has been doing a lot of work in this area, and I'm wondering whether you guys considered their work. And my second question is, where does the judiciary stand on this? Thank you.
Who would like to take check that? Camille, maybe?
Delegate Davis, thank you for your questions. I am very familiar with the way, in particularly the child welfare organizations and the child welfare system impacts communities of color. There's some disproportionality there with regards to how some parents are treated within that system for things that end up being criminalized that might just be associated with poverty or socioeconomic status. Because our focus was so narrow on specifically child abuse, allegations, and domestic violence in the context of custody cases, we weren't able to look with with that broader lens to look at those distinctions. But I think that what might be very helpful is if Maryland had a piece of legislation that required certain data points and metrics to be reported by locality to include race, sex, gender, age of child, and age of the litigants across the entire criminal justice, juvenile justice as well, and child welfare systems. I think that it's really important to look at that by locality. You're going to see lots of variations in those rates. Virginia looked at that, and you see a lot of fluctuation depending on which county you're in. And then when you look at it by county, you're going to be able to sort of micro target those counties that might need a little bit of help, that look like they are maybe over criminalizing when it comes to juvenile justice and having a disproportionate impact on communities of color based on socioeconomic status. So I'm sorry to say we didn't look specifically through a racial lens on this. We were looking at gender predominantly. But we did have a speaker by the name of Hera McLeod who did testify. She is a Black mother whose son was murdered, and she fought really hard to protect that son through multiple hearings. Maybe Paul Griffin can talk a little bit about her experience, but we do know it is impacting protective mothers who are members of those communities as well. So.
Paul, do you want to comment?
If I can find the mute button there, I'm sorry. Yes, we didn't look through it through a racial lens, but I can say anecdotally, in my observation experience, that African-American mothers are the worst treated that I've observed, particularly particularly if the father was white, but even when the father was African-American, the African-American mothers, I mean, I had one who was a doctor and the judge wouldn't call her doctor. Well, he would refer to other people as doctor. She was Miss. Even small things like that, maybe not small, but not directly related to the case like that. And certainly were disbelieved, in my view, inordinately. Regarding the Harry McLeod case, it's a terrible case. I was involved with it. I'll never forget that. I remember waking up in the morning and seeing the email from her telling me that her son had been murdered, which was exactly what she had told the court was going to happen. Tragic case. There was very compelling evidence the father was, in fact, a serial killer, if you will, that he killed probably his paramour and his mother, all for insurance money. Very compelling evidence that he was mistreating the child. And unfortunately, he was allowed to have unsupervised access. And I think on his second or third visit, he drowned the child. It was for a $500,000 insurance policy. He was later subsequently criminally convicted and is in prison in Virginia right now, thankfully, but that won't bring her child back. But it was an extreme outcome, though, of a typical case, I would argue. That just the mom was disbelieved. Exactly what she said was going to happen is in fact what happened. So she wasn't speculating. She wasn't a wild guess that she got right. She knew, she saw the writing on the wall and was seen as a bit hysterical. I think that Joan Meyer's research kind of backs that we have this unconscious bias that many people, actors have in here, that the moms are vindictive, and it's not always moms, but statistically it's more moms than fathers. It is. I mean, we have protective fathers as well, and we have mothers who commit child abuse as well, absolutely, including child sexual abuse. But statistically, it's more often, unfortunately, the father. But the moms, this bias that moms are seen as coaching the children, that this is just another high conflict case with an overprotective, hysterical mother. And sure, things happen like that in court, but they happen in all cases. They happen in contract cases. They happen in tort cases. There's nothing distinct about a custody case that a parent or a mother should be less believed there than a father as compared to a woman testifying in any other case. But somehow when it gets to these custody cases, these biases break through. And that was shown in Dr. Myers and Dr. Saunders' research about these biases. So I think that the training aspect we have for the judges and the specialized judges and the training we have for the other actors in these courts is extremely important. I think that will help address the racial and sexual biases, the racial one that Delegate Davis brought on. I really do think that having laws in place that will sort of, for lack of a better term, force the courts to consider this information, not make a predetermined outcome, but to consider properly the evidence before them and to overcome these biases they might have, is the only way we're going to have a systematic change in Maryland on this issue.
Thanks, Paul.
Okay. Delegate Davis, you're muted just in case you're looking for a follow-up. Are you looking for a follow-up or no? You are looking for a follow-up? Delegate, can we put Delegate Davis back up? There we go. Delegate Davis and Senator Coleman.
Yes, thank you, Chair Clippinger. And the judiciary. So someone going to answer that question?
I can answer that. I don't think judges like to be regulated. So I think that it's safe to assume there might be a little pushback from the Office of the Supreme Court. There might be and I think that there were some representatives from the courts at all of our subcommittee meetings and all of our meetings. They were there, they watched everything. They were intently very interested in what we were saying. I think that they're aware that there's some changes that will be coming in their direction. But traditionally, I think we'll be dealing with a little bit of judges feeling that they, this idea of judicial discretion is pretty sacrosanct. So we'll be dealing with a little bit of that, I think.
One more question, if I may, Chair, to Camille.
Yes.
Are you saying that they weren't involved in the discussion?
They were allowed to, they could raise their hand and ask questions or speak or give input, answer questions we had. So in that way, they were involved. But there were multiple document requests that we requested where we were refused documentation, if that gives you a sense of their level of cooperation with the task force.
And Camille, I can
Go ahead, Ann.
I was just going to say, when the work group was developed, we actually had them on the list to be part of the coordination and be members of the work group, and it was denied. So it was their decision not to be a part of this. So I just want to make sure everybody understands that.
I could add to that. Yeah, we wanted to have judges on this organization because we thought they would have
100%
input, but the word coming from the judiciary is that there were to be no judges on it. And I happen to know that entreaties were made to various judges, both sitting and retired, to come testify, and they were rebuffed. And it's very, very unfortunate. We would love to have their perspective. I would agree with Camille that we can expect some pushback because I don't think judges like to be told what to do. And I understand that nobody does. But I understand there's going to be a separation of powers argument, but I don't see how it's any different than this legislative body telling the executive branch they must have this type of training for their police officers or what have you, that it would be to tell the executive branch they must have this type of training. But that's just my view. But the Attorney General's office is going to weigh in whether there's a separation of powers issue there.
Thank you.
Okay, we are going to go now to Senator Hedelman, please. Then delegates Eric Ann Carden, Cox, Williams, and McComas, and Delegate Conaway, whose last name was inadvertently misspelled on the Zoom. Senator Hedelman.
Thank you, Mr. Chairman. First of all, thank you very much to the sponsors of the legislation who created this task force. You did tremendous work over these past 2 years. I will say, and I guess wanted to applaud Dr. Meyer's work. If I take nothing and remember nothing else about today, it will be that fathers proved to have committed child physical abuse still get custody in 25% of the time, which is pretty stunning to me. That's just, I read that and I was just like blown away by that. I've certainly heard my share of anecdotes and personal stories over the years, but that was stunning to me. So I'm glad that we have data now to back up what too many people have been experiencing in the courts. I do want to ask Mr. Griffin a question because you and I have had conversations over the years, and the issue that we spoke about a couple of years ago having to do with Nagel Hook's attorneys, I wonder if that came up and permitting mental health professionals to be able to waive the confidentiality with the child and have the judge rather than the attorney make that decision. I just wonder if that came up in the context of this.
It did. It was for a variety of reasons. It was decided that it might be a better, instead of a legislative fix, it might be a better judicial fix through case law. There has been one case recently, not directly on point, but that points to that direction. So we're actually hoping to get the right case to take up. It was brought up. It was not ultimately incorporated in the recommendations, Senator.
Okay.
Senator Hedelman, if I may, in one of the recommendations for judicial training, they asked, or they included understanding mental health, play therapy, so judges understand what it is our therapists do and how that could be used as evidence, or the judge can ask certain questions. Is the child eating? Is the child sleeping? We know that mental health professionals are not allowed in these court cases, but there are some of those in judicial training that could help. So that was one way the committee went about that issue.
Okay, and just as a follow-up, Dr. Meyer, could you talk a little bit about how many cases in this study were Maryland-based?
Yes, thank you for the opportunity and thank you for your comments. I want to just clarify that 25% of child physical abusers did not get custody. I put a correction in the chat and I'm happy to talk to you on email to clarify. 13% of fathers found to have committed either domestic violence or child physical abuse got custody.
Okay.
Okay, but 25% of those alleged to have committed child physical did get custody.
Okay.
It's a lot of data. In terms of Maryland, I don't know the number off the top. I was asked by someone on the working group for the Maryland cases, because one of the goals of the study is for states to pull down their state data from you know, we've coded all their cases. They can take our data for their state and do their state analyses. I don't know if anyone on the working group has been able to dig into that yet, but I'm happy to supply that case list to anyone who wants it. I think I'm hesitant to put a number out there. So, but you know, it wasn't an overwhelming number of cases. It could be analyzed for sure.
Thank you. Thank you, Mr.
Thank you very much. Delegate Erican.
Thank you so much, Mr. Chairman, and thank you so much to everybody that's been doing this really, really hard, emotional work for the last 2 years, particularly to Ann Hoyer for taking my phone call last year when I had questions about this very topic. I appreciate that. I personally know women who are not leaving their abusers because they understand what will happen to them and their children. They'll be separated. Smart women, some very educated women, they will not leave because they know what will happen in the state of Maryland if they try to. And they've said things to me like, my child is safer so that I can witness what's going on and at least be there to protect them, because if I'm not there, they'll be there without me. So I'm so glad that we're taking this up. I just love everything that you guys have drawn up here. I do have a few questions though. In terms of the first recommendation, the best interest recommendation, most of the men that I know who would fall into this category have great reputations and great characters, and they come across really, really, you know, as like the best members of society. So how, you know, I see you've included that in there still. How can we mitigate the risk of having just a really great communicator who's also an abuser, who seems like he's just a great guy, but really is hurting his children? And then is there any idea about the sufficient age number? I'm not sure where we're at right now, but that it's very hard to nail down where a child becomes sort of able to say where they want to live. And I'm wondering if we have sort of an idea for that. And then for the fourth recommendation, I know a lot of people who their attorneys suggest that they both get restraining orders immediately as soon as they decide that they're going to split up. You know, how are we going to sort of protect and it's mostly women in my experience, from having the abuser just be the first one to file, the first one to say, oh, she's abusive to the kids, and not have this whole legislation sort of be able to be weaponized against the mostly women who we're trying to protect with it. And then lastly, you know, on the training aspect, I love all the training. I think it's great that we're going to be training judges. I just want to know sort of who we're modeling this off of, who's going to be in charge of this training. How can we make sure that the training is actually staying relevant and it's not falling behind? You know, there's neuroscience that comes out every day that changes how we, you know, see the damage to children. And how can we as the legislature craft legislation that is really mindful of the rapidly changing environment? So those, I don't know who can best answer those questions for me, but whoever wants to just chime in.
Paul, do you want to take on some of that, and then Camille maybe?
Sure. Delegate Erican has asked some of the hardest questions we've been dealing with, and ourselves searching for answers. I can tell you, based on the thing you said about friends who don't leave, let me echo that. I can tell you the hardest discussions we have, absolutely the hardest, are when we have a client, again, usually a mother, coming to us and says, particularly in the area of child sexual abuse, my child disclosed that her father is doing this, this, and this, and here's perhaps some evidence I have to support it or not. A lot of times just the child statements, but I believe my child. I want to file right now to keep him away. The number of times we've had to look at the case and recommend against taking action, yet because of the very reason you cite, is extremely painful, and it's an awful conversation to have with the parent, basically saying you're gonna have to throw your child back into this pond full of piranhas and alligators, hoping that when one's going to bite, we can save the child, or say you're gonna have to come with more evidence. In other words, your child's gonna have to get abused more, in effect, for us to do anything. they are the worst conversations I've ever had, and this happened all too often. I don't have a lot of answers to all your questions. I understand what you're saying about I'm not sure we were necessarily have to look at the recommendation. We were recommending codifying exactly those best interest standards, or we were restating what the case law has shown us to be. I do absolutely think that in there with the evaluations that a judge would make, that abuse trumps all of it, or certainly most all of it. There would have to be a very compelling reason that the non-abusive parent shouldn't have custody. And I'm not sure what that would be, but there may be one out there. So I would highly recommend that when we get to that point with legislation, when we're recommending specific legislation, that's clear that these don't even come to effect until we have made it clear that abuse is not happening either of the child or the other parent. Because abuse of a parent, in our view, is a child abuse. And your body has already made a determination that domestic violence is bad for a child. We have that under 9-101.1 family law article. Unfortunately, the remedy isn't strong enough. We're just asking that there be teeth to the remedy. The court is required to consider it, and that is it. I've had judges go, okay, I considered it, and I'm not going to do anything about it. And they don't quite phrase it that way, but that's essentially what they're doing. We need to do what this body has done under Article 9-101, which is in cases of child abuse, there's essentially a presumption against custody. That should be extended to domestic violence. And I think those factors coming in before any of the best interest factors would make a great change. It would help. I don't remember the rest of the questions. I'm sorry.
My second question was about how we prevent the legislation from sort of being weaponized by like who files first. You know what I mean? A lot of times there's sort of difference given to the party that files first. If the man is extremely savvy or the abuser is very savvy, he files first when he sees his wife is starting to get distant. He could say, she abuses my kids, and then they're going to have to, the presumption of guilt is sort of put on her, and she's going to end up being even worse off than she would have if we didn't have this in place, is my worry.
Yeah, it's a concern. And actually, we as advocates, a lot of us kind of have this when we come up with some proposed legislation. One of the analysis that we do is how is this going to be used against us? For the very reason you cite, the abusers are crafty. And as Dr. Meyer can tell you, it's almost like they have a manual out there that they all read on how to fight these cases. And we happen to know there are these dark web websites that exchange information and do stuff. And once they figure out this, that'll be something we'll have to fight. The only thing I can hope for, I don't have an answer for you. I don't know if there is an answer for the legislative body. It would have to come through further education from judges. And it does get to the point where we don't think just because a person goes into court and says, the other parent did this, this, and this, that a judge should drop the gavel and rule that way. I mean, there has to be evidence, but there has to be an open mind to the evidence. There has to be an understanding what real evidence is in abuse cases. Why perhaps a mother who's testifying comes across horribly because she's got PTSD, perhaps because she's been battered, or she's got brain trauma if she's been battered also, and other compelling factors that the court should recognize, and also to have abolished hopefully some of the biases they have now, that this is just another high conflict case, or it's just another protective mom, or another vindictive mom rather, are the only ways I can think of to overcome what you're talking about, because I don't think there's any way we can put some we certainly can't make it for women only. Not only be unconstitutional, it wouldn't be right, because there are women abusers out there. But I don't know that there's a fix. Perhaps Camille does, or Dr. Meyer does, or Ann.
I think Joyce, I think wanted to add something.
I do. Delegate Erickson, so when you ask about the best interest factors in recommendation 1, as Claudia said, one of the stresses is extra weight to the physical and psychological safety of the child. And as we, in the recommendations, and so the factors could actually be further discussion among the work group and the legislators. But I do want to just say there is other evidence out there. And we're a Children's Advocacy Center. I do not represent either the protective parent or the abuser. We represent the interests of the child. And there's very few lawyers in these cases who understand that at a Children's Advocacy Center, we have a forensic interview. We have the best evidence of a child disclosing what, if anything, happened to him or her. Very few people subpoena our records, except Paul knows. He's one of the few people that's dropped a subpoena on us and asked us to play the DVD for the judge so that he or she can actually assess what the child said. Forget mom, forget dad. What are the physical manifestations of emotional distress? When the child has to go to mom's or dad's house, is there a change in his or her diet? Is she not eating? Is she not sleeping? Every single protective parent I talk to knows immediately. They all have it. They all have a diary. Judges aren't getting that information. So listen to children, listen to children's bodies. They tell you this is high conflict, but not for the child. So, you know, our goal here is to really focus on the kids and tune the adults out. That's child abuse. Domestic violence is different, but I just wanted to state that that's part of the training as well.
Anyone else? Camille, did you want to quickly add something?
Very quickly, when we were discussing all these recommendations, we did try to keep an eye towards how do you establish a bar of experience, knowledge, and expertise, whether you're dealing with someone training the judges or you're dealing with someone who's providing a custody evaluation. And I think we tried to raise that bar in the custody evaluator recommendations. With regards to the training of the judges, I think that it would be reasonable for the legislature to add some parameters to the level of expertise and define that. What does that mean? Not someone who simply has a MSW and wants to create a business where they're providing judicial training, but they don't have that clinical expertise and knowledge and experience related to the dynamics of domestic violence and exactly what you're talking about, how a victim might present, how an offender might present, how a traumatized child might behave. And those are all things that require a certain level of expertise. And I think that the legislature should look at codifying that and establishing that bar.
Okay, it is 13 minutes to 3. I suspect we're going past 3. Surprisingly, there are some more questions here, and I do want to try and get to them, but I'll just ask for everybody to try to be as succinct as you possibly can be. So it's going to be delegates Cardin, Cox, Williams, McComas, Conaway. Only one senator has asked a question so far, and that's just, you know, we can cast aspersions about the Senate another time, I suppose. But we'll go with Delegate Cardin, please.
Thank you, Mr. Chairman, and thank you very much to the task force. This is really tremendous, and I want to add my appreciation for all the work you've done. I was stunned to hear that a judge or judiciary was invited to participate and has declined, and that's something that we ought to take up maybe in the future. Two very quick questions for Professor Meyer. Very simple, I hope. One is, when you talked about the custodial loss or the loss of custody of the parent, are you talking about full, complete loss of custody or just partial loss? That's number one. And number two is, do you have any data on the number of people that were pro se versus being represented by attorneys? And is there a difference in how the parties act if they're being represented by attorneys? In other words, are they a little bit more, is it easier to get to the heart of it and to figure out a good solution in the best interest of the child? Those are my only two questions.
Thank you, Delegate Cardin. As I said, we analyzed one very stark question, but our data does cover partial losses of custody. It covers visitation. We're starting to go back in and do that analysis. But right now, the data we have is talking about when one parent starts with primary care, physical care, and ends up without it. That's what we meant by custody loss. And we didn't limit it to orders of legal custody or physical custody. We tried to analyze if an opinion was clear that one parent started with the kids, literally on the ground, and ended up without them. That's how we defined a custody loss. In terms of pro ses and representation, we started out trying to code for whether there were counsel in the case, and then we had to stop because the damn pardon my French, opinions were not consistent enough in telling us. So we knew we couldn't know. So we stopped coding for that. But I will say anecdotally and based on my experience reviewing hundreds of referred cases to DV Elite for appeal, having lawyers is absolutely no guarantee. I mean, someone like Paul, ups your odds a lot, and that's good. But Paul, we have only one of him. But most lawyers, the average lawyer out there is not protecting moms and protective parents from these responses by courts very well. Most of them don't know what's hitting them. Many of them represent accused fathers on the other 6 days of the week. There's a real lack of good advocacy even among the bar for protective parents. There's a lack of understanding. The complexity is off the charts. The things that are hard for judges are even twice as hard for lawyers who are trying to make a particular case, arguably. So and the emotional burden of these cases is very, very great. It's very hard to handle. And one way to handle it is to sort of simplify it and shortcut it and not deal with the horribleness of it. And that's what we see both with lawyers and I think perhaps also with judges sometimes.
I don't see Delegate Cardin with a follow-up. We're going to go to Delegate Cox.
Thank you, Mr. Chairman and members of the committee and our Secretary of State and those testifying. Thanks for your time today. I just want to commend you for your work. I know as all my colleagues would agree, it's a very difficult topic. I particularly like your rebuttable presumption issue to make that a proven perpetrator of child abuse, it's a rebuttable presumption that it's not in the best interest for them to obtain custody. I think that would be a great tool potentially. I have two concerns. One of them seemed to be addressed by Delegate Davis in the judiciary aspect. I just want to clarify that though from a not just a separation of powers issue, but from the issue and the Constitution of Maryland sections in Article 4, sections 1, 2, and 6, and then Part 3, Section 20A. But particularly Section 6, I draw your attention that the qualifications of the judges are defined in the Constitution, and they're allowed to, in the circuit courts, review everything under those jurisdiction and powers. And it says very explicitly that all judges shall conserve the peace and no prerequisites of any kind shall be allowed. Seems to me that the training requirement would be a prerequisite. I'll address that to Joyce Lombardi. And then the other issue is the presumption that joint custody is in the best interest shall not be allowed. And I actually had a bill in front of this committee last year to establish the fact that justice should be blind. And I had parties from all different backgrounds of life and all political persuasions supporting that legislation, that we should look at starting a custody case. The judge should be encouraged to look at it from a justice's blind point of view. And that was modeled on national or on other legislation across the country. So maybe I could ask Ms. Lombardi if she has comments, or also Ms. Meyer as the professor, if there are comments, either one would be fine as to the constitutionality, particularly Section 6 of the Maryland of Article 4, which says no prerequisites of a judge shall be required.
Thank you, Delegate Cox. I wish I had an answer on the constitutionality, but for me presenting the recommendations, that's not something that I have looked into. But I will say this, the recommendations are also very broad in that, as was done in 2014 and 2002, recommending that judges have additional training is something that's kind of been repeated. I think what you're saying is, does the legislature have the power to mandate it? And that's not a question that I personally, as a lawyer, can opine on.
Could I, real quick follow-up, if I could, that you're not recommending that lawyers are unable to be advocates in these cases. In other words, an attorney can take a child custody case even if they don't have specialized ongoing annual training, but the judges would have to be trained. Is that my understanding of the recommendation?
Yes, sir. The recommendations were that judges who take these cases, and then the court personnel such as the best interest attorney, and those attorneys, the privilege attorneys, would have that specialized training. Yes.
If I may take a quick stab at the justice is blind proposal, I think judges think they're starting out very blind. We could argue about which biases we're seeing. I think people in my field think that there's a lot of bias against mothers alleging abuse. And there's a lot of bias for fathers to protect them from those allegations and to protect their rights. But I'm sure the fathers community would say the opposite. And I'm not sure what a justice is blind legislation would add to the mix. They know they're supposed to be neutral. They know that everyone starts in an equal position before they hear the facts. The question is, what do they make of the facts and what do they do with the facts? So I guess, I've long fantasized that if we could degender litigants, we would see some very different outcomes. Like if it were possible to make judges not know who is a mother and who is a father, we would see different outcomes. Because I think the implicit biases are quite strong about, how mothers are supposed to be or not be, and fathers perhaps as well. And we can't really erase litigants' genders. And so the question would be with a proposal like that, what's the hidden message it's sending? Is it sending the message that fathers are getting a short end of the stick and you got to protect fathers? Or is it sending the message that mothers are, because it doesn't, usually it sends the message that you've got to protect fathers, that kind of provision. And that's why I would have some hesitancy. Certainly the 50-50 provisions that are circulating the country are all pushed by fathers' rights advocates.
Thank you.
All right, thank you very much, Delegate Cox. Delegate Nicole Williams.
Yes. Actually, my question is sort of kind of piggybacking off of Delegate Cox's question, ironically enough. So with regards to the recommendations, I saw the recommendations to the judiciary, recommendations regarding evaluators. My question is whether or not there was any conversation or discussion, though, about recommendations as it relates to the lawyers, members of the bar, especially those who are representing the parents who are trying to protect their children, whether or not that was part of the discussion by the work group.
I'm happy to touch on this a little bit. We did talk about that, and obviously it's of grave importance. Paul is an exception. He's an expert in what he does. I think when we look at the overall training of the judges, it's, as you can well imagine, it's going to be very difficult to go in guns a-blazing and train everybody, right? To train all these private attorneys who are being hired by individuals. So for us to believe that we could do that when they're private entities is probably slim to none. But what I feel personally, and what the group has come up with in terms of the training of the judges, I believe it will heighten the awareness, the education, and the expectations of the others coming into the courtroom, like the lawyers. So if the judges are saying, well, wait a minute, what's going on here? And they have the education in the toolbox, they're going to recognize, that the lawyers are sometimes not equipped to handle these cases. So that's why I feel very strongly, and everybody who knows me and has talked to me over the last 10 years, I feel very strongly about the judges, creating that foundation, creating that precedence in the courtroom where the judges are now raising the bar of expectations for everybody else who comes in to protect a child. And I know I keep beating a dead horse about this, but it's the same as if you have a primary care physician and you go and you have an ailment that they don't understand. and they send you to a specialist. That's the appropriate thing to do. And that's, I think in a nutshell, if I really want to simplify this, I think that's exactly what we're talking about right now. So I hope that helped a little bit. I hope that answered your question in a roundabout way.
Delegate McComas.
Thank you. I want to thank everybody. I want to thank the two chairs and also the group that worked on this. You did a really, I mean, it's an impressive work, and I want to be able to take the time and read it over. The thing I will say is that historically, the judiciary does not want to be told what to do. And I don't know if you all are aware of it, but there's no requirement for CLEs for the bar. In other words, you don't have to take any CLEs. Now, you might for your insurance issues purposes, but not for the bar to renew your license. So that, and many states have required CLEs. So perhaps the way to do this is to if you could get the bar to do buy-in and say, hey, there's required CLEs. And of course, I think you might have a lot of lawyers beating on you, but that might be one way to solve that problem. The other thing is I realize that physical abuse is horrible for kids, but there's also the emotional abuse, which that's very hard to define. And basically, I'm kind of concerned, did you guys deal with drug abuse or alcoholism of one of the parents? Because that can be very bad for a kid to live in that kind of environment, even if it doesn't produce physical or sexual abuse. I mean, just seeing that and, harsh words and everything. So I was wondering if you dealt with that. And the other quick comment I want to make, because I'm very interested in what you have to say to that, is that, Maryland through the years has really lowered the threshold for domestic violence from the clear and convincing to the preponderance. And that was very significant and long fought. But the other thing is, one thing I've observed in the cases I've had is a lot of times the evaluator will evaluate the mother as histrionic, because, mom, to take away a child from a mother is more traumatic than if you're going to take it away from a father. I mean, generally speaking, because, it's just that mother thing, but that doesn't say that, there aren't good dads and everything, but it just seems like I've kind of wondered if you've ever tracked the evaluations that they've come out, quite a few mom's histrionic. And I think that sort of poisons the well. But the other thing is, I'm really curious as if you dealt with the alcohol and the drug abuse, and those are kind of my questions.
Jennifer, is that something you might address, Jennifer?
Yeah, I'll go ahead on the drug abuse. I think we were looking at child abuse and neglect. So that would include for us, maltreatment of a child if a parent is under the influence and drug abuse. And I think the training, the training recommendations for custody evaluators, attorneys, is really identifying, the extent of traumatic stress, perpetrated by a parent, whether it's neglect, physical abuse, sexual abuse. But we did spend some time on emotional abuse, and the training criteria that we started to outline would as well, specifically how is that defined and what's the scope of that, because you're correct, a lot of the invisible wounds, including the neglect or unpredictable caregiving with substance use, also create toxic stress and should be part of the decision making for where the child resides.
Mr. Chair, I just have one brief. The other thing I wanted to ask, and I guess this would be of Dr. Meyer or any of the academics, was there any coordination between who had the most money that they're going to win the case, or they're going to kind of be the winner? Because I used the thought that, he who has the goal rules.
That's a great question. And unfortunately, again, there's so many things judicial opinions do not tell you, and that is definitely one of them. If they, I would have hoped they would tell us if someone was represented, but it wasn't always clear. We could have surmised from that if one party is represented and the other is not. We could have surmised that one has more financial capacity, but we couldn't even establish that, I'm afraid. But you're right. You do see that certain echelons of abusive parents use litigation abuse. They come back and back and back and back, and they bankrupt the protective parent and they wear her down, and until they get what they want. And there is an effort. There's been an effort in Tennessee and a few other states. I know Washington State and maybe California are looking into whether they can legislate to address litigation abuse and how best to do that. It's tricky, but it's a concern.
We did hear that from a number of the victims who told us literally they were spending hundreds of thousands of dollars and still lost and they were basically bankrupt. They had to sell their houses. It's been devastating. And we've heard this from a number during the time over the past year from a number of victims that came and testified specifically to that.
Okay, Delegate Conaway.
Thank you, Mr. Chairman. Can you hear me?
Yep.
Hello, everyone. Thank you for coming in and testify. I'm going to make this simple. I'm going to go to my third question, and I'm going to piggyback off of something that one of the good delegates said. Is there any consideration for environmental, cultural, or even the sexual differences in what could be called child abuse? In other words, let's say in Baltimore City, in the African-American environment, where there's a high level of violence, the way that a child might be disciplined might be different than in a place that's rural. So I'm wondering, is there any difference in the definitions across the board? That's my question.
Who best to answer that?
Well, I can just add to this. Earlier, Ms. Meyer was talking about the difference between maybe the male, the way a male would react and the way the female would react. So we know there's a difference potentially between the sex of the person that we're talking about, but is there also a difference between the environment or the person's cultural? When you say cultural, one religion might handle a situation one way, another religion might handle a situation another way. Let's say beating a child or spanking a child versus punishment, that type of thing.
I think Camille might jump in on this.
I think in the Maryland Code, there are definitions for child physical abuse, child sexual abuse, particularly as it relates to Child Protective Services investigations. I understand that there's a lot of effort to be culturally competent, which is, I think, what you are talking about in terms of any type of child welfare or criminal justice response to different communities. But I think that there is a pretty well-standing definition of what would constitute child physical abuse. And I don't think, and Paul, maybe you can correct me if I'm wrong, I don't think that spanking is probably on that list.
No, it's not.
But certainly if you're leaving bruising or marks or any type of permanent injury or temporary injury, that would probably meet the definition of felony child abuse.
Well, let me say this. I don't think that what you described as not being spanking is a typical spanking, because as I know spanking, there might be bruising or redness, or you could tell that someone was hit. Not permanent injury, but you could tell someone was hit. So therefore, while you refer to this Maryland Code, I just want to make you aware of the fact that a lot of people might not see their discipline the same way that the Maryland Code is describing.
Paul, do you have some insight on the Maryland case law as it relates to that?
Well, I could say anecdotally that I agree with Delegate Conaway, and I think judges anecdotally in the more urban areas look at corporal punishment differently than they would in Montgomery County or Howard County. That's purely anecdotal, and I'm sure some judges hearing, most jurisdictions hearing that might disagree with me. I have had cases where the argument was this was corporal punishment. The judges the father stood by what he had done, and it's gone both ways. Where the courts, usually it's defined by the case law in Maryland. The law does not define this in Maryland, and it's one we should probably work on too. In other jurisdictions, if there's any marks left after about an hour, I think after being struck, a bruise at last. That's a definition of crossing a line to abuse. Maryland doesn't have that. And I think that, I mean, kids get spanked. Courts aren't really going to get that generally that upset about it. It's when you start getting into leaving bruises that you might see a difference amongst the jurisdictions. Montgomery County might, or some of the judges in some places would see that as being abuse. And some, as you described in Baltimore, would see that as still maybe harsher, but still corporal punishment.
You should just say, to be truthful and honest, that sometimes young boys have to get punched out by their dads. I mean, you might disagree with that, but that is something that happens. And if you're seasoned, I'm sure you're aware of that.
I'm aware it happens. I don't know that I agree that it has to happen.
Yes, but I'm just saying that you are aware that that does happen.
Oh, it does happen.
Yes,
I'm unfortunately aware of that. Regarding the cultural issues, I know that in the literature on child abuse, that's covered a lot, that you have to be careful recognizing cultural differences, and that goes towards some things like cupping and other Eastern medicine aspects. Leave marks, burns, light burns, or bruises.
That's medical. Cupping is medical, isn't it?
Well, it's Eastern medicine, and families themselves.
Yes, I know what it is.
Okay. But a mother or a father or grandparent might be the one performing it, not someone with any type of medical degree. And I understand, but I'm not sure about this. This wasn't our area dealing directly with Child Protective Services. From what I understand, though, they are to be cognizant of that there may be cultural issues there. But at the end of the day, regarding punching out a child, I mean, we're gonna have to agree to disagree on that. I don't think the science supports it as an effective way. And I think if you get into actual punching a child, I think the vast majority of judges I've seen would, if in fact they found it was punching, would agree that would be child abuse.
Okay.
Could I add one possible gloss on this discussion? I think one might be able to distinguish between discipline, even physical, which is administered as discipline, versus abuse, which is someone being angry and taking it out on someone physically. And so one might draw that line. I don't know if there's a practice in child welfare to draw that line, but it seems to me that would be a very reasonable line to either put in legislation or train judges about, that, culturally speaking, here's a line you can draw. It's not purely just what the action is, but the intent and the behavior around the action. And if someone is very controlling and coercive and is abusing the mother and then punches at the kid, you've got a whole abuse scenario, as opposed to someone who says, I got to teach you, you got to know, you can't do this. This is the way I know how to teach you.
Right. You shouldn't have stolen. You shouldn't have hit the lady and pushed her down and take a pocketbook so you get a punch.
I'm not disagreeing with Paul. I also would not like to see a parent punching, but I'm just saying that one could factor in more context in making distinctions.
And I can say anecdotally, while we have seen the defense arise of this was discipline, we at Child Justice generally don't take on cases that we believe were discipline that might have gone a little too far. We think it was abuse. I mean, we had one father striking a baby.
Well, that's
with the hanger.
Yeah, I'm in total agreement with you.
I understand. And just so you know, we'll take a case like that, even if he tries to define it as discipline. But if we get a case where, as you described, it was somebody truly disciplining their child from a point of anger, we might not.
And my position is maybe that shouldn't be done. The dad shouldn't punch out the son if he's wrong, but he needs to know. So we have a lot of these when you're talking about what's the law and what's not the law. We have a lot of laws that are known here in Annapolis or known in other places, but are not really known, let's say, in Baltimore City. So you might break the law. You might think it's okay to slap your child, but someone else witnesses and say, "Oh, that was child abuse. You slapped your child." You say, "Well, the child was shoplifting. I caught him. I slapped him, and now you're in trouble." You need to know the law. What I'm trying to get to is a lot of these laws, and while we're talking about this and the training and all this, we need to also include educating the public on what the appropriate activities should be. That's all I'm getting to.
Sure.
Thank you.
Absolutely.
Delegate, I think we're a little over time. I want to ask a question very quickly, and then we're going to wrap this up. A couple quick questions. In my experience with the judiciary being involved with task forces, they generally don't take positions on policy ever, because they view that as the task of the legislative branch, and they view it as a separation of powers issue. So it doesn't necessarily surprise me that they didn't fully engage in the work group. But you indicated that they did not provide documents, or there were documents. I believe it was Ms. Cooper who indicated that they did not provide documents that you requested. What documents did you request that they didn't provide?
We wanted to see the Maryland judges bench book. That was for
Oh, that was denied.
purposes. That's what I wanted to see.
You wanted to see the bench book. Okay.
Yep.
Which, as an aside, ought to be public. As an aside, I think that the bench book should be public. It ought to be, there's due process issues. I think if judges are going off of a body that they're not sharing with the public, it's in this bench book that is their interpretation of case law or of legislation, then I think lawyers ought to have a right to know what that is so they can possibly rebut it or use it or what have you. So we really would like to see that.
Okay, I have further questions about the separation of powers, and the question was asked directly before. I don't know that it was answered. I don't think we have time to do it again. I just will say for the record that I'm not entirely convinced that there isn't a separation of powers issue, but I believe that perhaps the Attorney General will have to weigh in on that score. With that, I think we're certainly at the end of time. I want to thank everyone, the Secretary of State, and others for your time and bringing this to our attention. We'll certainly be working on these issues and the legislation that arises from the work group here once we go back on January the 13th, just one short month away. All right.
Thank you very much, Mr. Chairman. Thank you very much. We appreciate the effort and the opportunity to talk to you all.